Yes.
Thank you, Your Honour.
You don't want to say anything further in relation to it?
I beg your pardon, Your Honour?
You don't want to say anything further in relation to the letter?
Well, Your Honour, as I indicated yesterday, my submission is that section 67B can be, and in my submission should be, interpreted differently from that set out by those representing the church parties yesterday, and that matter is raised in the second page, about halfway down of this letter. And it's suggested in this letter that in the circumstances of the Royal Commission taking a different view, contact was made overnight with some of the people concerned, including Cardinal Pell, and what's attached to the letter is a statement from Cardinal Pell where, among other matters, in respect of Mr Green, he says the conversation that Mr Green gave evidence of yesterday did not happen, and in respect of the evidence Mr Ridsdale gave yesterday, he says, I have previously made a sworn denial of these allegations, and I reiterate that denial. Now, no other material has been provided in the context that the church parties referred to some of the people, including Cardinal Pell. So my submission can only be in respect of Cardinal Pell, and in my submission, that statement which has been provided to the Royal Commission is one of denial rather than difference of recollection. And in my submission, the contents of that statement would call into play paragraph 67A. So the issue of whether or not paragraph B of 67 should be read in a particular way becomes somewhat redundant.
Yes. Mr Gray, do you want to say anything about this letter?
No, Your Honour, the letter speaks for itself, and that is our position on my instructions.
Well, I just need to say a couple of things. Firstly, the letter has, it would seem to us, within it, a misunderstanding. As Ms Finesse has just indicated, the position as we apprehend it may be is that there will be direct conflict between witnesses as to whether or not a particular event occurred or a particular statement was made. Either because there's been a mistake, or because one or other may not be telling the truth and should be disbelieved, then both limbs of clause 67 will operate. Now, maybe that hadn't been appreciated, but it should be clearly understood.
Your Honour, I'm sorry. Sorry.
Now, secondly, the letter raises the question of the process that's been followed by the Commission in previous case studies. Nothing which we have done in order to progress the case studies, the public hearings, in an orderly way, diminishes or cuts across the right of any party to seek to have evidence tendered or a witness called. It's not alone a matter for the Commission to seek out evidence or seek out witnesses. If a party wishes evidence to be called, or evidence to be tendered or a witness called, then that is their right, and that right is exercised by asking counsel assisting to make appropriate arrangements for that to happen. However, in the ordinary course, in order for the orderly running of the Commission's business, it has been our approach in the past, and will continue to be, that we will seek out witnesses and seek from them statements so that as I say, we may proceed in an orderly fashion. The fact that prospective witnesses in this case study have not yet been asked for a statement is a reflection of two things. Firstly, as with any Royal Commission process, we are engaged in an investigation. This is not a process akin to a conventional trial when all the evidence is necessarily collected before the case begins. This is an investigation. And as you know, and everyone knows, this case study is proceeding by way of two separated public hearings. No one should assume that that's been done for other than a deliberate purpose. And I stress again, this is an investigation. That's what a Royal Commission does. Thirdly, Mr Gray, I need to confirm, if it's not already plain, that just because the church parties have chosen to conduct their case in any of our case study hearings in a particular way and not ask witnesses questions is not a matter that we will have regard to when making any findings that we believe is appropriate to make when we complete our reports. It's a matter for you and those instructing you as to the course that you take. But the practice directions and what I've indicated yesterday and confirm again this morning, I hope makes plain that merely because the Church chooses to conduct its case in a particular way, that does not bind the Commission in any way at all in relation to the approach it will take to the findings which it might make.
Thank you, Your Honour. We've done our best to put forward our appreciation of the position as it presently stands in the letter, and I've heard what Your Honour has said.
Well, what I'm saying plainly is the letter is not, does not reflect what the process for the Commission, or the process by which the Commission will pursue its task. And it would seem that there's been some misunderstandings that are reflected in the letter, and I trust those misunderstandings have now been swept away.
Could I ask us to ask one question, Your Honour, in case there's another misunderstanding on my part? Is the Commission indicating that findings would be made before the second set of hearings?
No, of course not. No. It's one investigation, one case study proceeding by way of two sets or two periods of public hearings. I stress again, as I stressed yesterday, that no one will be denied procedural fairness, but that doesn't mean that the investigative process won't take the course which the Commission has decided should take. All we will do is make sure that at the end of the day, and before we make any findings, everyone has been afforded procedural fairness.
Thank you, Your Honour.
Yes, Ms Finnis.
Might I just raise one additional matter in relation to the letter, which is now Exhibit 2819. There is reference to the fact that the church parties were provided with witness statements after witnesses associated with the church parties had already provided their statements, with one exception. Now, the word after is underlined, and I can only take that as being somewhat of a criticism of the process followed, and as counsel assisting, can I indicate that the way in which material is served on the parties depends upon the stage at which any investigation has reached, and there is no set practice that will be unwaveringly followed in respect to the service of material.
Yes, thank you for that. And it just leads me to repeat the observation that this is an investigation, and the process by which that investigation is undertaken is a matter for the Commissioners. At the end of the day, the necessity and the obligation of the Commissioners is to afford parties procedural fairness. But that does not mean that in the course of the investigation any particular pattern or internal procedure will be followed. What it means, though, is that at the end of the day, and before we make findings, procedural fairness, an opportunity to respond and make submissions is afforded to any party. Yes.
Your Honour, I call